Welcome to the Vicente webinar on what happens next with the Florida MMTC licensing process. My name is Sally Kent Peoples. I am with the law firm of Vicente. I'm a partner in the Florida office. I'm licensed in Florida, Oregon, and Colorado, and my focus is on getting my clients licenses in the cannabis and psychedelic space. I handle all aspects of getting their business up and running, getting them their license, making sure they have property nailed down, and advise on compliance and regulatory matters as their operations continue, and of course, helping them exit efficiently. I have been working in the state of Florida for about 11 years in the cannabis space, so you're in good hands today. My law firm, Vicente, is the premier cannabis and psychedelics law firm in the US. We have been doing this for about 14 years, which is a pretty long time when it comes to cannabis. We were very instrumental in passing the original adult use law in the state of Colorado. And since then, we have expanded to offices all over the US. So if you are looking for a partner to help you expand your business, whether through licensing or an IP agreement, or you're just interested in getting in the industry and you don't know where to start, please give us a call. Specifically in Florida, Vicente and myself, we have had such success in getting our clients MMTC licenses. So far in Florida, there have been 3 licensing rounds. The first 2 have actually issued licenses via those processes, and we had clients that we drafted applications that were successful in both of those rounds. We also represented several clients in this most recent process, and we hope to see similar success with them. We act as the quarterback for these licensing application processes. We have a dedicated merit licensing team that's filled with policy experts, economists, attorneys, and technical writers that act as your support team throughout the licensing process. We're very unique in this, and we have the best track record of any other licensing team in the US. So I'd like to kind of give an overview of where we're going to be going today. I'm going to touch on the application timeline so you can see where we've been and where we're headed. I'm going to touch on the notice of intent to award, and then what a final agency action will mean and what that will trigger and what actions operators need to take thereafter. I'm also going to go over some best practices of things you should be doing now, and then touch base on what is in the future. So I can't believe it's been over 2 years, but the emergency application rules for this specific application process that's ongoing today, those were issued back in December of 2022, so quite some time ago. And then the application was due 5 months later in 2023. We all anticipated that the notice of intent to awards would be issued thereafter. And now we're a year and a half later and they still haven't been issued. I know this is very frustrating for a lot of folks. So we're here to discuss that today. So what is a notice of intent to award? If you are selected for an MMTC license, you will receive a written notice via letter, via certified mail, and an email letting you know that they have a notice of intent to award you a license. If you are not selected, you will also receive notification of such and procedures kind of outline what steps you can take to contest the determination. What's key here is a notice of intent to award is not your ability to start operating. There is a time period allotted for those who are not successful to contest the determination. So there is a time period you'll have to wait before the final agency action is taken. Once that final agency action is taken, then you can consider yourself licensed. So since they do outline the process that you can take to contest the determination, what we've seen in Florida is that many people do take the opportunity to fight if they were unsuccessful in the application process. People spend a lot of money on these applications, and it's expensive to apply. And plus, these licenses are the most valuable ones in the US, with the unlimited ability to cultivate, process, and dispense. So I will anticipate that there will be some disgruntled applicants that will file suit against the Department of Health. So this potential litigation may delay the final agency action, and people should be prepared for that. So let's say we've gotten through the potential litigation, and you do actually get that license through your final agency action. Within 10 business days of that action, you have to post bond in the amount of $5 million. I know that applicants are already aware of this. This was a requirement in the application. You had to show your ability to be able to post that bond in the application, but I know some time has elapsed, so you might want to just check in with your bond company, make sure that you still have that ability to do so, and be prepared to post that bond. So you may not initiate any cultivation, processing, or dispensing operations until you have received authorization from the department to do so. So the takeaway here is you can't just start operating the company and growing marijuana and selling it until you get the approval, further approval from the department. Within 60 calendar days of the final agency action, you'll have to request cultivation authorization. For processing, you have to do so within 120 calendar days, and for dispensing, you have to do so within 180 calendar days. So what does that look like? After you have submitted a request for authorization form, the department will then send someone out to physically inspect your facility. And they may or may not, but they may identify some omissions, deficiencies, or they may even give you a violation notice if you do not submit a corrective action plan within 7 days. So there'll be a little back and forth between the department and you, if you do have some omissions or deficiencies. And all corrections will have to be completed within 30 days of that initial identification of the deficiencies. So this is some suggested pre-licensing action items. I know everyone's sitting around waiting for the announcement to be made. So what could you be doing now to get ready? So I highly recommend that you sit down with your team and review your application very carefully. Just read the whole thing through, because that is the template for how the state is expecting you to operate your company. And you can't really veer from that without taking agency action, without submitting a variance. So if you are needing to make some changes to how you are going to operate, then we can certainly help you submit a variance after the final agency action. So the state sees this application kind of as your manual for how you're going to operate. And that's important to keep in mind. So anytime you make changes, you'll have to submit a variance. So here's some other suggested pre-licensing action items. Throughout your application, you may have identified some architects you'll be working with, some vendors you'll be working with, accountants. Make sure that any obligations you have to them, some financial obligations, have been met. Same thing with your team members. Maybe you agreed to hire, give someone a success fee once you got that license, maybe a medical director or your compliance director, or your cultivation manager. Any identified team members in your application that you had obligations to, make sure that you're ready to fulfill those obligations. Again, it bears repeating, reread that application, sit down with all your team members, make sure they each understand their specific job functions, their responsibilities, and how to do those under and compliant with Florida law. So this is the big one, your local permits and inspections. And we're going through a few of this with our clients today. Most of what the application is addressing is your state obligations. Remember that you'll have to deal with the local municipalities wherever you have a facility located. For example, you might need to get a conditional use permit to extract on your cultivation property. These things take some time and may require a hearing that, again, can be a lengthy process at the local level. So something you should look into now and make sure that you're prepared to take those steps. And you might want to get the ball rolling on those things so that you're prepared to request that cultivation, processing, and dispensing authorizations in the time permitted. You may actually want to initiate your facility construction. As I know that people don't want to pay that money now to do that, but maybe take all the steps without actually breaking ground. If you decide to break ground and move forward, you may be able to sell that to an applicant that was successful. So maybe all would not be lost, but certainly you need to make sure you're prepared to meet that 60-day cultivation authorization. SOPs and handbooks. A lot of our clients say, we don't really need those because, we've been operating in California all these years, so we'll just use those. Please do not take that. Take the opportunity now to have us rewrite those SOPs and make sure that your handbooks are compliant with Florida law. Florida operates very differently from most other states. So I think it's a good idea just to have us look at everything. We already have a lot of those materials prepared, so we're happy to provide them. Or we can take a look at what you have and amend accordingly. Hire and train your staff. Again, sitting down with them, reading that application, making sure everyone's aware of what their duties are. And you mentioned in your application your training plan. Make sure you have that ready to go. We're happy to provide any sort of tweaks to what you have in there and advise on the best way to initiate that. We have a compliance team that helps our clients on a national level with all of those steps. Testing, which is very important that you have arrange some sort of relationship with a testing lab. I know that a lot of people already identified a testing lab in their application. Make sure that testing lab is still operating. It's been 1.5 years since you submitted, so there might be some changes since then. And of course, just wanted to touch on make sure your administrative tasks are taken care of. Make sure your building has internet, phone, insurance, any of those sort of insurance providers or ancillary service providers. Our firm has a national network that we can dial you into and make introductions as needed. Make sure you have someone to oversee your records. Make sure that any marketing and advertising you are planning on doing is actually been approved by the OMMU. I know a lot of people said this is the way our logo is going to look, maybe in their application. If that's changed, it's going to have to get, any changes will have to get reapproved through a variance. There was a social equity aspect in the license application, and make sure you go through that and remind yourself of all the commitments you said you were going to make to local communities. Maybe you said you had some state and local partnerships. You want to reach out to those that you were going to partner with. You just want to make sure that whatever you said you were going to do in your application, you continue to do that. And then ongoing compliance. You've got a license. Let's make sure you keep that license and avoid getting violations. We have an excellent compliance team that can be on call anytime. We can act as your compliance director. And the great thing about having a law firm be your compliance director is that anything that we discover is not discoverable in court. So if you ever face a regulatory violation, then anything that we have been talking to you about is not discoverable because it will be covered by attorney-client privilege. And finally, getting a lot of calls by applicants, which makes sense because after 1.5 years, any properties that you identified in that application that you've been paying on month after month to keep live and to keep the possession of, a lot of applicants, most applicants have just run out of capital. It's been very frustrating that they have been having to pay these landlords under maybe a purchase contract or a lease to keep these properties live. If you have let go of those properties, please give us a call. We can talk about how to address that once you do get a license. And you may want to start looking for a replacement property because you will have to identify them once you do that variance. So this is something that a lot of the MMTCs kind of missed back in 2015. Within 12 months of that final agency action, you will have to pass a GMP inspection by a nationally accredited certifying body for all your processing facilities, or you won't be able to process. So in conclusion, I would love to talk to you if you have applied and you're interested in us helping navigate moving forward your operations, if you're looking to expand or you just need a partner that can support you in any way you need. I think one of the most interesting things about our firm is we do have an in-house economist. So if you're talking to investors, it's a really good idea to sit down with him and make tweaks to your pro forma, make sure they know what they're investing in, and we're happy to talk to them about risk associated with that. If you're interested in giving me a call, here is my call or email. Here is my email. And I look forward to hearing from you. I am located in Florida in Jacksonville, but I travel a lot and look forward to meeting with you. Thanks.